Hello, my name is Jeff Gottlieb. I'm the owner of the law offices of Jeffrey Gottlieb. We have offices here in Huntington Beach as well as a satellite office in the city of Riverside. The focus of our practice is serving families that have a disabled child, such as with Autism-Down syndrome, or often a genetic condition that leads to intellectual disability. Today, the focus of our discussion is estate planning for a family with a disabled child. That will typically involve the formation of a living trust along with what's referred to as a special needs trust. First, a little bit about our background and what we do for our clients that have a disabled family member. We do conservatorships, we do family law involving a disabled child, we do adult child support, we also do SSI appeals, special education, and one more. That is regional center appeals where there's wrongfully initial denial of eligibility for someone to become a consumer of the regional center. That's mostly what we do here. There's a few other things that we do, but that's the bulk of what I just described. Okay, first of all, let's talk about what is a trust and how is that distinct from a will. A trust and will are first very similar, so let's start off there. Primary purpose of a trust and primary purpose of a will, even though there's other things that can be done with those vehicles, as we refer to them as, that is, they both are means to distribute assets at the time of death of the person who set up the trust or will. That's the easiest way of describing it. A distinction between a will and a trust is that wills have been around for hundreds of years, literally. Trusts are relatively newer means for distribute assets at time of death or even disability. The problem or the challenge with a will, it must be probated. That means it must go through the court process. There's an attorney who will be employed. There'll be court schedules. There'll be lots of paperwork, pleadings, similar type documents that have to be filed. There's accountings that have to be done quite often if a will goes to probate. A trust doesn't go through any of that, meaning the person passes away who set up the trust, and typically right away when things settle down a little bit, assets can be distributed or they can be managed as per the terms of the trust. So the trust does not go through the probate process. You don't necessarily need an attorney to administer it. You just have to do some reading of how to do it, and hopefully your attorney that helps set up the trust explain to you the administration that's someone who will become a trustee will be engaged in. Now, so let's talk a little bit about the terminology here. But again, I want to back up to something, and that is a trust has a lot more advantages over a will in terms of not going through the bureaucracy of the county courts. Now, terminology. A trustor is probably the person who's listening to this video, or trustors. These are the people who set up the trust on behalf of other people. A beneficiary, your neurotypical child, your non-neurotypical child who has autism maybe, whomever that may be, you as the trustor are going to be the one who sets up the trust, usually with the assistance of an attorney, and develops and memorializes the terms of how those assets are to be distributed. Extremely important. It could be a co-trustors, meaning that it could be a husband and wife as co-trustors. Doesn't matter. The concept is still that of a trustor. Then there is a person who's the trustee. Typically, after your death, you've designated beforehand who's responsible for managing assets for distribution. Then separately, there's a beneficiary, and that's the recipient of the assets or the cash flows, whatever it may be, that's set up in the trust, like rental property may produce income for a disabled person. So anyway, that is the terminology that's important. Trustor, trustee, and beneficiary. What's really important is the phrase or the word trustee and trustor. They both, if you notice, have the words trust, T-R-U-S-T, which means is that when you set up someone to be the trustee to take actions after you pass away to distribute assets or distribute income, whatever it may be, you have to make certain you can trust that person. Otherwise, the trust doesn't have the oversight of the court, which is a benefit that there is oversight. You avoid the oversight when you have a trust, which means you really need to trust the person who's going to be distributing the assets that you put into the trust. So the word trust is very important. Matter of fact, in our practice, we take typically 2 or 3 months, and sometimes a little bit less, sometimes a little bit more, working with our clients, providing consultation, and usually it's a flat fee for what we do in developing the trust, etc. So we throw into that package consultation. And the two important things are to decide is, one, who do the assets go to, and who will be the trustee? And if that trustee predeceases you, who will be the successor trustee? These are important decisions. We don't like to have what's called holes in a estate plan, which means is no one knows who takes over when someone passes away other than the trustor, but the trustee passes away or is incapacitated, him or herself. So we take a lot of time with our clients making certain that's understood. The other part that's important is, which we will talk about in a short while here, is about the special needs trust. You must make certain that the right amount of assets and that are put into the special needs trust. And you also have to make certain whether or not it's a liquid asset or an income asset producing such as property that goes to the beneficiary, which will typically in a special needs trust, actually always, will be the disabled family member, autism, down, whatever it may be. So those are important points. If you know nothing else from this video, is basically what is a trust and what's important considerations that you must think about. Now, for our law firm and probably for most other law firms, there's certain basic items that go into a trust. So let's go over those briefly. The first item is the trust itself. The second item is the special needs trust. The third item will be a healthcare directive for yourself. It could be you and your wife, or you and your husband, whichever it may be, or partner, it doesn't matter. You must or should have a healthcare directive in case you get sick prior to your death, of course. You're incapacitated. You maybe have Alzheimer's, dementia, or whatever it may be. You want to make certain that someone else, and usually your spouse or your children or whatever, who are adult children at that time, make decisions on your behalf. That's extremely important. You don't want to have those decisions made or gain the right to make those decisions or not have the right to make those decisions when you're incapacitated before your death, obviously. The other thing that you will receive, or document, I should say, not thing, is a power of attorney over financial affairs. So if you get incapacitated, you obviously want someone to make decisions about your own health and healthcare requirements. But assets may have to be handled prior to your death, and a power of attorney will allow that to happen. So in case your child who's an adult needs access to assets or income prior to your death, that person can make that decision, or assets need to be sold for your own healthcare, whatever it may be. So those are the primary things that go into a living trust package from hopefully any attorney. The other part is if your children are still minors, you may want to designate someone to be a guardian. You also may want language in there that upon your death, people know about your son or daughter who's disabled, such that you give them explanations of what their care is and their requirements will be. That's an important language to go into any trust or special needs trust. So those are the items that you will get. So what type of assets can go into a special needs trust or the trust? And we'll talk about the terminology living trust in a moment. They can be a house, they could be rental properties, they could be pensions that distribute assets in there. It could be retirement accounts, it could be stocks, bonds, cash in your checking or savings account, personal items, whatever it may be. Those items will go into a trust or into a special needs trust, designated specifically in the special needs trust as distinct as distributions for any other members of your family. So those are the items that go in there. You must, and this is where there's mess ups, excuse my simple language, when people go online to do a special needs trust or a living trust or whatever it may be as a tool, what they will often do is do everything right except fund the trust. Funding means you must identify the items to be distributed at your death, and that must be written. It's called Schedule A normally, it doesn't matter the terminology, but in Schedule A you'll have designated the assets to be distributed at your death. If you fail to designate those and fail to transfer title during your lifetime, that trust may be useless. This is a little bit technical, so let me see if I can rephrase it to make it simple. Whatever assets you want distributed at time of your death, when you set up the trust, those assets must be designated within your trust document, special needs trust or your living trust or whatever it may be. And as you add assets or dispose of assets during your lifetime, your trust needs to be modified. You don't need an attorney to do that. We provide the forms. You can do it yourself. It's not very complicated. The problem is people sometimes forget to do that. There's a way to bypass, I shouldn't say bypass, there's a way to get around items not in your trust. As a general rule, if you don't list all the relevant assets in your trust, that part of your estate may go through probate. So you got a trust and you got probate going on. Total mess. You want to avoid that. The easiest way to avoid that is you designate all major material items in your trust and you amend or whatever you may do or remove an item from your trust. Next thing is this is important before we get into special needs trust. Typically, people get what's called a living trust. And that's also referred to quite often as a revocable trust. Made a mistake there. So living trust is a revocable trust. That means during your lifetime, prior to your death, of course, you are able to revoke the entire trust, which shouldn't happen, it doesn't happen very often, but you also have the right to amend it, modify it, add heirs, you got a new grandchild, whatever it may be, you want the flexibility to amend it during your lifetime. So that's why it's called revocable. Again, it's usually not about revoking the entire trust, it's about the ability to amend it during your lifetime. There's a little bit of fiction that's created in law to allow you to do that. If you're the trustor or co-trustor setting up the trust, you're both a trustor, trustee, which means as a trustee, you're managing your own money and you're also the beneficiary. It's a little bit confusing, but it's a fiction of law that makes the total trust revocable. Now, what does happen when you pass away, you passed away as a trustor. You're dead. Excuse my language. You're gone. The trustee then becomes a person you designate, which may be your spouse, your partner, your best friend, your nephews, your children, adult children, whatever it may be. Then the trust becomes non-revocable. I shouldn't confuse that. The trust becomes non-revocable upon your death. That means the beneficiaries that have been set out, they are your beneficiaries. Your trustees take over, or trustee takes over to manage the process of distributing the assets, or however the terms of your trust is set up. So a living trust is a revocable trust that becomes non-revocable at the time of your death. Sorry, tongue twisted there a little bit. Next item, what is a special needs trust? It's really quite simple. And that is, and I tried to use the word simple quite a bit, there are certain federal requirements for programs such as Medi-Cal, which is called Medicaid, not Medicare, but Medicaid in other states other than California, and SSI. What you want to make certain is that when assets are distributed to your disabled child through a special needs trust, that there's no money or assets outside of that trust. The reason is I'm coming up with a general rule, which is getting modified over time, but there's a restriction on how much assets a person may have to receive government programs. So what you don't want to happen is that assets are distributed directly to your disabled child, even if it's under the management of someone else as a trustee, but there's no special needs trust set up. As a consequence of not having a special needs trust, even though you have a trustee, is that those assets will not be countable towards the restrictions on receiving SSI or Medi-Cal or other programs. So let's give a simple example. Let's say there's $100,000 that you want to leave to your Down syndrome child or autistic child, and you do not have a special needs trust. The government will terminate any payments for SSI to that $100,000 is used up. So basically, you're losing dollar for dollar. All that money that you set aside for the benefit of your disabled child is completely wasted, which is why you set up a special needs trust. Let's say hypothetically you put $100,000. It doesn't matter if it's $1 million. The concept is identical. That money in there is not countable as part of the qualifications for SSI or Medi-Cal or other programs as well, which means is that you can use those monies to supplement the needs of your particular disabled member of your family. So let's come up with a simple example. Let's say your disabled son, who's now 45 years old, and you've passed away, and that child has Medi-Cal. Medi-Cal has a very narrow network. It's good that's around, but it's not as good generally as private insurance. Well, let's say that the trustee, which may be your neurotypical child, wants to take the Down syndrome or autistic child to a specialist that's not in the Medi-Cal network. Medi-Cal may say no. Well, you can always reach out into your special needs trust to supplement Medi-Cal as an example. There's lots of different examples we could go through of the benefits, but this is one that you could comprehend fairly easy. You could then send your disabled child to that specialist and use the money from the trust to pay for the cost of that specialist that would not otherwise be payable or retained by the Medi-Cal program. You can also do something else. You can also buy under Obamacare, put aside politics, but if you could get a health plan that's a private plan that supplements, private health plan that supplements Medi-Cal. So it may be Blue Cross, Blue Shield, and that may be a better way of going because there's no, because health plans cannot discriminate based upon pre-existing conditions. You're basically paying for a 45-year-old to get health care who's disabled, and the extent doesn't matter, the same price as someone who's not disabled and pays for health care insurance. Again, a little bit complicated now, but it's not Medi-Cal. The Special Needs Trust allows you to do lots of things, lots of purchases, lots of supplementary items for the benefit of your disabled child when you pass away as the trustor that benefits directly your disabled child. So let me summarize what a Special Needs Trust does. I may have overcomplicated. It allows you to shield assets to not count as a denial for eligibility for government programs. That's the easiest way of doing this, and that's important for the benefit of your disabled child. It's a great way to help your disabled child now upon your particular death. That's it. Estate planning for a family with a disabled child. If you have any questions, you can give me a call at my office, 562-699-2412. That's again 562-699-2412 regarding the establishment of a living trust along with a special needs trust. Have a good day and have a good week or a good weekend. Thank you.